My name is Kim McKenna, and we're super excited that you're all here with us. We'd like to first take a moment and thank BKD. They have been our gold sponsor of our chamber webinar series for the entire year, and we're super excited to have them on board. If you haven't been to a webinar, I just wanted to give you a few points as to what we are doing here. The goal of our webinar series is to provide presentations on timely topics that impact the business community. So we're super excited to have with us Jody Duvall of Cline, Williams, Wright, Johnson, and Oldfather to go over recent developments in litigation and enforcement of the Americans with Disabilities Act and associated laws, and to discuss potential risks to employers and provide practical compliance guidance for employers and practitioners. So before we get started, just a few housekeeping items. We will mute you all during the presentation, but we will have Q&A. Jody, you want to do it throughout the presentation or you want to do it towards the end? You let me know.
Go ahead and submit the questions during the presentation. We can just address them all at the end. Perfect.
Okay, so please enter your Q&A in the chat and we'll talk about them at the end. So with that, I'm going to turn this over to Anna. Anna is with BKD and she's going to share a few highlights about what BKD's been up to.
Thank you, Kim. We are happy to be a sponsor of today's webinar. I know this is such a timely topic, and so really looking forward to hearing how we can expand our knowledge as we're navigating through these continued challenges. BKD really values our relationship and partnership with the Chamber. We are, in addition to being the sponsor of the webinars, we're proud to announce our recent investment with Northern Colorado Prospers and look forward to those investments in the future. Just a quick little highlight, BKD is a full service accounting firm. We provide auditing and tax, as well as a multitude of different consulting services, such as forensics, evaluation, wealth management, risk management, and many, many more. One of the things that we're very proud of is our approach to the COVID-19 environment. We've got a multitude of publications and just a wealth of information out there relating to COVID-19. If you search BKD COVID-19 resources, just Google it, it'll get you to our website, and there's plenty and plenty of information that we are proud to have been releasing really throughout the entire pandemic to our clients. So with that said, I hope everyone enjoys the webinar, and I will turn it over to Jody.
All right, thank you, Anna. And as Kim mentioned, I'm a labor and employment attorney here in town. I work for a law firm we call Cline Williams. The full name's Cline Williams, Wright, Johnson, and Oldfather. We are a full service law firm representing business clients throughout northern Colorado, Wyoming, and Nebraska. My particular practice focuses on labor and employment, though. I generally represent employers with regards to legal compliance and when compliance breaks down and you have a dispute with an employee or something like that. And it's very timely that Anna mentioned navigating through the issues, because over this last year, trying to navigate through COVID compliance really kind of feels like trying to follow one of these road signs. And I have some good news and bad news. The bad news is that when it comes to ADA compliance, particularly during COVID, there is no clear roadmap. Each circumstance is unique, and the general overriding principles are that employers must be flexible and act in good faith when it comes to responding to employee ADA requests. The good news, though, is that in this webinar, we're going to hit on many of the things you should be thinking about when an ADA issue comes up. Like I said, each situation is unique. There's no one-size-fits-all solution for ADA compliance, particularly in the new COVID world that we live in. But hopefully after this webinar, you'll be aware of general themes with regards to ADA compliance, and we'll have an idea of what your company needs to do to be in compliance. At the very least, we hope that this webinar will allow you to spot potential liability concerns when they pop up, so that you'll know when to call legal counsel. With the roadside sign theme, keeping with that theme, we're hoping this webinar will be like a hazard sign on the road that'll help you avoid hitting invisible cows or running into a bridge. So what are we going to talk about? We're going to go over just some general ADA refresher information. I'm sure that most everybody sitting here has a general understanding of what's required by the ADA. But it never hurts to have a refresher, and that'll help us springboard off into a discussion of how the rules have changed during COVID times, specifically some workplace COVID-19 issues. And then we're going to talk about where the rubber meets the road with the litigation update on a few things that are going on nationwide. So Americans with Disabilities Act became law in 1990. It's a civil rights law that prohibits discrimination against individuals with a disability in all areas of public life, including jobs, schools, transportation, all public and private places that are open to the general public. And the purpose of the law is to make sure that people with disabilities have the same rights and opportunities as everybody else. The ADA is divided into 5 titles, or you may hear them referred to as sections that relate to different areas of public life. As it relates to employment, it helps people with disabilities access the same employment opportunities that would be available to people without disabilities. It applies to employers with 15 or more employees, although there's a caveat there. Most states have a state corollary law to the ADA that provides a lot of the same protections, and many of the state laws have a much lower employee threshold. So here in Colorado, we have the Colorado Anti-Discrimination Act, which applies to all employers, regardless of how many employees you have, assuming you have more than 0 employees. The ADA requires employers to provide a reasonable accommodation to a qualified applicant, and a reasonable accommodation essentially is a change in the working environment that accommodates an employee with a disability so that they can do their job without causing the employer an undue hardship, which generally speaking means too much difficulty or expense. The ADA defines disability. The definition of disability is up there on your screen. It's a physical or mental impairment that substantially limits one or more major life activities of the individual, person with a record of such an impairment, or a person who is regarded as having such an impairment. So it protects people who have a current disability, people who have a record of a disability, or people who are regarded as such, meaning that you can be found to have committed disability discrimination if you treat an individual who's not disabled like they are disabled. The guidelines that interpret the ADA provide procedures and processes to follow for the reasonable accommodation process. It also addresses medical examinations and inquiries. Generally speaking, disability inquiries and medical examinations, to be legal under the ADA, they have to be job related and consistent with business necessity. The ADA also imposes confidentiality requirements on medical records that employers obtain about their employees, including that the medical information has to be kept separate from an employee's personnel file in a secure file. The ADA is enforced by the EEOC, although, like I mentioned on the last slide, states typically have their own state laws that provide the same protections, and those laws will be enforced by state agencies. In Colorado, the state agency that enforces the state version of the ADA is called the Colorado Civil Rights Division. And what happens, generally speaking, is when there's an alleged violation, an employee or an applicant will allege violations of both the ADA and the state law equivalent when they file a charge of discrimination. And then the EEOC and their state counterpart will determine amongst themselves who handles the investigation, which means that sometimes you may have a situation where a state agency investigates violations of the federal ADA. A few other laws that frequently come up when you're considering ADA compliance: the Rehabilitation Act. There's a lot of overlap between the ADA and the Rehabilitation Act with regards to reasonable accommodations, non-discrimination protections, and rules about medical exams and inquiries. Title VII of the Civil Rights Act is an anti-discrimination law that prohibits discrimination based on race, color, national origin, religion, and sex. We're going to touch on that briefly in this webinar because it can require an employer to provide a reasonable accommodation for a sincerely held religious belief, which we've seen pop up quite a bit during COVID pandemic. And the test for a religious accommodation is different than a reasonable accommodation for a disability. The Genetic Information and Non-Discrimination Act, which is typically referred to as GINA, protects an employee's genetic information. And it also has been implicated during the COVID pandemic because it restricts what an employer can ask about its employees' families. So how have the rules changed? According to the EEOC, they haven't changed. The EEOC has reiterated throughout the pandemic that all equal employment opportunity laws, including the ADA, continue to apply during COVID. But with that said, there are compliance considerations and specific situations that have cropped up during COVID that have required unique adaptations of the laws. We're going to touch on those here in a little bit. But the EEOC has created an excellent web page that addresses a plethora of common questions that employers have had about compliance with their non-discrimination laws. They've maintained this web page since the beginning of the pandemic. It's been updated continuously with new guidance on key issues as we go through different phases of the pandemic. One thing to keep in mind, anti-discrimination laws do not prevent employers from complying with guidelines and suggestions from the CDC or state and local public health authorities. And that point has been repeatedly driven home by the EEOC. So accordingly, we typically recommend as a low risk option of compliance to comply with CDC guidelines, guidelines provided by state and local public health authorities. But with that said, there are a few areas we've seen that have popped up that can trip up employers on multiple occasions since the start of the pandemic. One of those issues is the definition of the term disability. As you remember from just a few minutes ago when I read the definition to you, the definition of disability is a physical or mental impairment that substantially limits one or more major life activities of the individual, person with a record of an impairment, or a person who is regarded as having such an impairment. So there's two key factors here that are important in determining whether an employee's medical condition is a disability, meaning that they would be entitled to protections under the ADA. And they're bolded on your screen. The first factor is whether the impairment is one that causes a substantial limitation. And the term substantially limits is generally construed broadly by both the EEOC and by courts that have had to construe the term. It shouldn't demand extensive analysis, but that is one of the key factors. The second key factor is whether the activity is a major life activity that is being substantially limited. And the regulations that implement the ADA define and provide a huge list of what can constitute a major life activity, things like performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, sitting. You get the picture. It's a long list of items. And again, this is going to be construed fairly broadly in favor of coverage under the ADA. So with that in mind, I put together this hypothetical here. So we'll go through that. An employer has an assistant manager with moderate asthma. The employer allowed the assistant manager to telework during the COVID pandemic. When the employer called employees back to the office, the assistant manager requested to continue working remotely as a reasonable accommodation. The employee had never asked for an accommodation before the pandemic for his asthma, and the employee's asthma has never flared up at work. The employer denied the request because the employee's asthma was not a, quote, disability within the scope of the ADA. And looking back up at the definition of disability, it's understandable why the employer denied the request for a reasonable accommodation here, because there's no disability, right? The employee never asked for an accommodation due to his asthma before the pandemic. The asthma clearly doesn't affect him at work. There's no indication that it ever actually substantially limited a major life activity while the employee was at work. So the employer was correct here, right? In determining that there was no reasonable accommodation required. Well, if we came to that conclusion, I hate to break it to you, but that's the wrong conclusion. And this is actually taken from a case that came out of the federal court in Massachusetts called Peoples v. Clinical Support Options. And now granted that the opinion in this case is in the context of a temporary restraining order, the case ultimately settled before the court could rule on the merits, but we don't have a whole lot of case law on this issue as of yet. So even a judge's opinion issued in the context of a temporary restraining order is instructive. And in that case, the federal district court in Massachusetts acknowledged that there may be a separate standard for determining whether an individual has an impairment that qualifies as a disability during the COVID pandemic. And these quotes on your screen are taken directly from the judge's opinion. The judge said the plaintiff is likely to prevail on their contention that the asthma is a disability, at least during the COVID pandemic. The plaintiff has pled that because of their asthma, they're at a higher risk for serious illness or even death if they contract COVID-19. Now note, there's no discussion here of whether there's a substantial limitation of a major life activity here. It's the whole determination of whether there's a disability seems to hinge on this higher risk of serious illness or even death that's not included in the ADA at all. So the court acknowledged that there's possibly a separate standard for determining whether an individual has an impairment that substantially limits a major life activity, thus rising to the level of disability during the pandemic. And the people's decision is in alignment with another federal case that we had come out of the Western District of Louisiana called Silver v. City of Alexandria. In that case, the plaintiff was a city council member who suffered from aortic valve disease, systolic heart failure, and had a permanent pacemaker. And notwithstanding that the plaintiff in Silver may have had a disability under the ADA, even in non-COVID times, the judge stated a totalities of the circumstances test that essentially says an employer has to take into account an employee's underlying conditions and whether those conditions make it more likely that the employee is at high risk of severe illness from COVID. And I highlighted some key language here from the opinion that I think is a bit questionable, but regardless, it is the opinion of a federal judge, so we need to take it seriously. In response to the employer's argument that the employee's disability isn't really a disability because it's kind of situational. It wouldn't even be a disability unless there was COVID, unless there was a COVID pandemic going on. The judge said that the argument fails because of the simple and logical explanation of things the way they are. When you hear a judge say something like that, it kind of makes you scratch your head a little bit, particularly with the clear language of the ADA that requires substantial limitation of a major life activity. But regardless, like I said, this is a federal judge's opinion, so we need to take it seriously. In the next paragraph, the court announced this totality of the circumstances evaluation, essentially said that COVID has turned everything on its head. The pandemic is the unprovided for case. And so the court essentially said that, there's a disability here because of the higher risk for severe illness. And regardless of whether we agree with the tests that courts are applying in a COVID world to determine whether an underlying condition does not actually substantially limit a major life function, and determine whether that should be considered a disability, we at least know that this is how courts are applying the law and we can adjust our conduct accordingly. Then once the issue of whether an employee has a disability has been ironed out, the next step in the process under the ADA is to determine whether a reasonable accommodation exists that would allow the employee to perform essential functions of his or her job without placing an undue burden on the employer. And what we've seen during COVID, the EEOC has really been keying in on are things like inflexible leave rules, work from home policies. The EEOC has counseled flexibility here. And as we just discussed, a reasonable accommodation may be required. And if an individual has a condition that puts him or her at a greater risk from COVID-19, and the employee asks for an accommodation to reduce their possible exposure. So things like allowing leave is a reasonable accommodation, or allowing an employee to work from home. And with these sorts of issues in mind, you want to consider additional potential disabilities under the ADA that may be implicated here. Employees with certain pre-existing mental health conditions, for example, things like anxiety disorder, obsessive compulsive disorder, PTSD, they may have more difficulty handling the disruption to day-to-day life that has accompanied the COVID-19 pandemic. The interactive process is still required. It's an informal process that employers enter into with employees to determine whether or not there's a reasonable accommodation available that doesn't place an undue burden on the employer. And the EEOC has suggested specific reasonable accommodations that may work during the COVID pandemic, including temporary job restructuring, temporary transfers to a different position, telework, modifying a work schedule or shift assignment to allow an individual to perform safely the essential functions of their job while reducing their exposure to others in the workplace. And if it's not an obvious or already known disability, an employer may ask questions about an employee's disability, essentially whether they do have a disability, what the scope of it is, how that's going to affect their ability to perform essential functions. Employers can request medical documentation for disabilities that are not apparent to determine whether or not the employee has a disability as defined by the ADA. questions you may want to ask in these types of situations: how does the disability create a limitation? How will the requested accommodation effectively address those limitations? Whether there's an additional or another form of accommodation that could effectively address the issue, and how the proposed accommodation would enable the employee to continue performing essential functions of the position. The EEOC has provided guidance that the interactive process may be delayed during the COVID pandemic, given real world realities. But employers should still attempt to address requests for reasonable accommodations as soon as possible. We've had a couple other specific COVID issues that have popped up with regards to reasonable accommodations. Family member exposures. This is an employee coming in and saying, I have a high risk family member at home. I need a reasonable accommodation. The ADA does not require an accommodation for an employee without a disability based on the disability related needs of a family member. But that doesn't stop an employer from being flexible here and working with their employees. One thing you want to keep in mind, though, is whenever you start to make exceptions to the rule or treat employees differently, you want to be careful of associational-based discrimination claims. You want to be careful of treating of disparate impact claims where you're treating one group of employees differently than another. So things to keep in mind if you have employees who come home or who request those types of accommodations. Automatic telework is another issue that's popped up. If you have an employee who comes in and asks for automatic telework, do you have to provide it? Again, it's not required. We recommend that you go through the interactive process with the employee and determine whether or not reasonable accommodation is required, and if so, what that reasonable accommodation may be. If the employee doesn't have a disability-related limitation that requires teleworking, then you don't have to provide it as an accommodation. Or if the disability-related limitation can be met in another way, employers are entitled to address those needs with another type of reasonable accommodation. One thing I want to keep in mind, though, is that if an employee requests a telework arrangement as a reasonable accommodation, and at some point during COVID, you had employees working from home, teleworking, that will be a relevant factor to consider. And if you're going to argue that an employee cannot satisfactorily perform all of their essential functions while working remotely. Another issue that employers have asked about is what do they do with pre-existing knowledge of an employee's underlying condition? So if you have, going back to the people's case, if you have knowledge of an employee's asthma, what do you do with that knowledge? One thing that we're telling employers is you can't exclude employees from the workplace just because of your knowledge of an underlying condition. An employee's disability, for example, asthma, has to pose a direct threat to the employee's health. Sorry, let me get back there to that slide. Has to pose a direct threat to the employee's health before you can exclude an employee from the workplace. And even if they do pose a direct threat to the health of, to their own health or the health of other coworkers, then you need to go through the reasonable accommodation process, the interactive process, and determine whether that's a reasonable accommodation in the specific circumstances. So essentially, we're counseling employers that if they have pre-existing knowledge of an underlying condition, you can contact employees and go through the interactive process with them. Let them know that you are aware of their underlying condition, and ask them if there's anything that the company can do to help them safely perform their essential functions, perform their job duties in the workplace. One thing that you want to keep in mind here, though, you're never required as an employer to eliminate essential functions of a job as an accommodation for an individual with a disability. And another thing, generally speaking, the burden is on the employee to notify the employer that he or she needs a reasonable accommodation. It can be an oral request, it can be a written request. There's no need to use magic words like reasonable accommodation, but employers will be deemed to be on notice of a need for reasonable accommodation if an employee or a third party, for example, an employee's doctor or spouse, states that the employee has a medical condition that requires a change at work to meet the medical need. Another type of specific reasonable accommodation that we've seen employees requesting, modification of an employer requirement surrounding COVID. So some employers are requiring employees to wear masks or gloves, wash their hands regularly, or take other steps to reduce the spread of COVID in the workplace. Again, initially, we recommended that employers follow CDC and local health agency guidelines and orders when it comes to personal protective gear, including the Larimer County mask mandate that's going into effect tomorrow at noon. But with that said, employers are permitted to require employees to wear masks and take other reasonable steps to reduce the spread of COVID, including requiring vaccinations. And this might raise some issues with disabled employees. For example, if you have a deaf employee who uses lip reading to communicate, and communication is an essential function of the job, you'll need to go through the interactive process with that employee for a request for reasonable accommodation and determine if there's an accommodation that exists that doesn't cause an undue hardship on the employer. The undue hardship standard under the ADA means unduly costly or expensive, substantial, disruptive, or would fundamentally alter the nature of the business. So this is a pretty high bar for employers. You have to show that there is, in fact, a significant difficulty or expense before you're going to be allowed to deny a reasonable accommodation based on undue hardship. Also, the fundamentally alter the nature of the business portion of the undue hardship standard means that there could be an accommodation that's cost-free on paper, but that fundamentally alters the employer's business that would justify denying a reasonable accommodation. And this means that there may be different considerations in different situations. For example, teleworking may cause an undue hardship based on whether it's a temporary situation or whether it will last for an unknown duration. More frequently than a request for modification of COVID requirements due to a disability, we've seen employees assert objections to personal protective gear or vaccinations on the basis of religion, which may also require an accommodation under Title VII of the Civil Rights Act. So we're jumping out of the ADA and into Title VII of the Civil Rights Act. Title VII defines what a sincerely held religious belief is, and it essentially includes moral or ethical beliefs as to what is right and wrong, which are sincerely held with the strength of traditional religious views. So this begs a few questions of the employer. Is the belief truly a sincerely held religious belief, or is it a personal philosophy or a philosophical choice? And the Supreme Court has differentiated between sincerely held religious beliefs from those that are essentially political or sociological or philosophical in nature. And this can be a tough call for employers. The EEOC has counseled that employers are generally supposed to assume that an employee's stated religious belief is sincerely held unless you have a good faith and objective basis for questioning the religious nature of the belief. And there may be some factors that you have to consider here in determining whether the belief is sincerely held, including, did the employee, how long has the employee had this alleged sincerely held religious belief? Is this a newly adopted belief in response to your vaccine or mask mandate? What's the source of the employee's religious belief? Is it a general distrust of vaccines? Is it news that they read online? And if so, that's likely not going to be enough to be considered a sincerely held religious belief. Just like with the ADA, if you have an employee who asserts a religious objection to a COVID requirement, you need to go through the interactive process with that employee. And if you have a reasonable suspicion that the employee's asserted religious objection to the requirement is not sincerely held, the employer can take steps to investigate the sincerity of the employee's beliefs. For example, in these circumstances, employers are permitted to inquire with third parties, for example, clergy members, employees' fellow congregation members, things like that, regarding the employee's belief. And employers can also consider inconsistent behaviors of the employee with regards to the alleged religious belief. For example, if an employee asserts a religious objection to a vaccination, but the employee participates in the company's annual flu shot clinic, the employer can consider that factor in analyzing the sincerity of the employee's religious belief. If you conclude through the interactive process that the employee's objection is or could be grounded in a sincerely held religious belief, that doesn't mean a free pass for the employee. you have to go through the remainder of the process, identify reasonable accommodations. Can you meet the requirements through masking? Can you provide a reasonable accommodation and meet the employee's religious objection through masking or frequent COVID tests, socially distanced working, a change in shift, an unpaid leave of absence, although as I'm sure many of you read online, United Airlines is currently being sued by employees that they put on unpaid leave of absence following their vaccination requirement. The employees are asserting that that's not a reasonable accommodation to put them on unpaid leave of absence. But there may be reasonable accommodations that are out there that you'd be able to offer to the employee to meet their religious objection. And then you need to make a decision on the accommodation request. You may conclude that no accommodation is available that would be considered reasonable or that would not cause an undue hardship on the company. And this is the difference between the ADA and Title VII. The undue hardship standard under Title VII, which applies to religious objections, is much lower than the ADA. Anything that would require more than a de minimis cost or burden on the company is considered an undue hardship. Whereas, go back to the slide ago when we're talking about the undue hardship under the ADA, it's a significant test that the employer has to meet. Under Title VII, anything more than a minimal cost or burden on the company is an undue hardship. Non-monetary factors can be considered, and although we don't have cases yet in the COVID context, they will be coming. There are cases that have to do with general safety requirements where the employer denied reasonable accommodation requests based on the effect they would have on a safe workplace, and the court upheld the employer's denials of reasonable accommodation. So there's favorable case law out there. The burden is not, or the hurdle is not high for employers to clear to show an undue hardship based on religious accommodation. Another thing to keep in mind, you're not required to provide the accommodation that the employee requests if there are other reasonable accommodations available. And you're not locked into an accommodation that you select here. If you try an accommodation out for a while and it doesn't work for some objective reason, you can go back and revisit the accommodation with the employee and adjust as necessary. And if the employee refuses all of the options you provide and demands a specific accommodation, you may have no choice but to exclude them from the workplace. Or, as I mentioned earlier, put them on unpaid leave until the circumstances around COVID pandemic abate, although that may be a little more fraught with legal risk. We recommend looping in employment counsel in any of these situations, just to ensure that the company's decisions reduce potential liabilities to the greatest extent possible. A few other issues to keep in mind, and while these issues have not popped up as frequently as reasonable accommodation issues in the context of COVID, there's still issues that employers should have at the top of their mind. Harassment. The U.S. Department of Health and Human Services has said that long COVID can be a qualifying disability under the ADA. We'll talk about long COVID here in a second. But employers should be aware of that with regards to their treatment of employees who have COVID. For example, an employer's attitude and comments toward employees who have missed work due to COVID should be viewed through the lens of whether the employer's conduct could potentially expose it to liability for harassment. Similarly, the employers should be on the lookout for comments made between employees. This may be harder to do if your employees are working remotely, but employees should be held to the same standard regarding harassment if they're working remotely or if they're back in the workplace. Few steps you can take to combat potential harassment that may occur as a result of the COVID pandemic. You want to keep your lines of communications open with your employees. Let them know that fear of COVID should not be misdirected against individuals because of a potentially protected characteristic. You want to have robust policies regarding harassment in place. Make sure that they are provided to employees, and make sure that your policies have reporting mechanisms for harassment. Retaliation is another matter that's popped up. Under no circumstances should employers take an adverse action against an employee due to the employee's COVID status. And in states like Colorado, which currently still requires employers to provide paid sick leave for employees to deal with COVID symptoms, employers should be careful with regards to discipline or termination decisions that are made close in time to an employee's paid sick leave for COVID. Before you take any of those steps, discipline or termination, consider whether there's a legitimate business justification for the adverse employment action, and make sure that you document the whole process. As with any time you take an adverse action close temporally lead to an employee's protected conduct, here requesting and taking time off for COVID, you should closely scrutinize the level of risk you are exposing the company to for a retaliation claim and loop in legal counsel if necessary. Associational discrimination is another issue that's popped up. Essentially, don't treat employees any differently with regards to terms and conditions of employment. If they have a family member at home with COVID, here again, you want to be paying close attention to potentially harassing comments made by coworkers. And again, as I mentioned earlier, you're not required to provide a reasonable accommodation based on the disability of an employee's family member. One of the frequent issues that comes up for employers with regards to COVID is what they can and cannot ask with regards to an employee's COVID situation. The general rule with regards to asking medical related questions under the ADA still applies. If an employer wants to make a disability related inquiry or subject employees to a medical examination, they have to be job related and consistent with business necessity. Important for COVID times though, this standard is met when an employee will pose a direct threat due to a medical condition. The EEOC has classified COVID-19 as a direct threat to the workplace, which means that the job-related and consistent with business necessity hurdle has been met. But there's a big but here. When asking about symptoms, you want to limit your questions to symptoms associated with COVID-19. You could find yourself in hot water if you're asking questions about symptoms related to COVID-19 and you ask questions that could inadvertently disclose another disability that the employee has. Employers are permitted to ask employees directly if they've been diagnosed with or tested for COVID, if those employees are coming into the workplace. But note here that questions should not be asked of employees who are teleworking and not physically interacting with coworkers. The reason being, in those cases, an employee's COVID-19 symptoms or diagnosis would not constitute a direct threat to the employee's coworkers. Therefore, asking about it would not be consistent with business necessity. Another thing you want to think about is whether you're going to ask individual employees as opposed to asking all employees about their COVID status. If you're going to ask individual questions, make sure you have a reasonable belief based on objective evidence that the person might have COVID-19 before singling an employee out for questioning. You also want to steer clear of asking questions about an employee's family members and their symptoms, diagnosis, or exposure to COVID-19. As I mentioned earlier, GINA prohibits employers from asking employees medical questions about family members. That information is considered genetic information, and employers are by and large prohibited from asking about that. But employers can ask more general questions about whether employees have had contact with anybody diagnosed with COVID-19 and still obtain that same information. But make sure you appreciate this nuance and what you can and can't ask about under GINA. Other ways you can determine an employee's COVID-19 status: taking their temperature. Taking an employee's temperature is considered a medical exam under the ADA and generally prohibited. But because COVID has been identified as a direct threat in the workplace, employers are permitted to take this step. You can require COVID-19 testing. The EEOC has said that COVID testing administered by employers that's consistent with current CDC guidance will meet the ADA's business necessity standard. Testing has to be accurate and reliable, though, to meet that standard. Note that the EEOC has said antibody testing does not meet the ADA's job-related and consistent with business necessity standard for medical examinations. Therefore, requiring antibody testing before allowing an employee to come into the workplace is not allowed under the ADA. And an antibody test is different than a test to determine if somebody has an active case of COVID-19, which would be considered a viral test. And one more note on confidentiality, as I've said before, all medical information must be kept as confidential under the ADA in a separate file from the employee's personnel file. With that said, you may still report the name of an employee who has COVID to a public health agency consistent with that agency's rules and regulations. Just a couple more issues that have popped up, specific questions. If you have an employee with COVID-19 symptoms, what can you do and still be in compliance with the ADA? You can require them to stay at home. You can require a fitness for duty note from a doctor. Given the practical realities, though, of how busy medical professionals have been during the pandemic, this may not be a realistic option. you may be required to simply comply with quarantine guidelines provided by the CDC. If you have an employee who's refusing to answer questions about COVID-19 or let you take their temperature, you can bar the employee from the workplace. You can ask about the reasons for their refusal. And a really hot issue right now, especially with President Biden's federal mandate that he announced last month, is what you can do with regards to mandatory vaccinations, what you can require. We're advising employers that they do have solid legal ground to require vaccinations. EEOC guidance says it's okay as long as the policy does not have a disparate impact on a protected class of employees. We have a DOJ, Department of Justice memo from July 2021. Now note that both of these, the EEOC guidance and the Department of Justice memo, are from before we had full FDA approval of vaccinations. So even then, the DOJ stated their opinion that employers could require vaccinations before allowing employees back into the workplace. We also have the federal mandate from President Biden and the upcoming emergency temporary standard that we're anticipating OSHA will issue, requiring federal employees and contractors to be vaccinated. Federal employees, including remote workers, have to be fully vaccinated by November 22nd. Federal contractors will have to be vaccinated by December 8th. Those were both provided by executive order from the Biden administration. The upcoming ETS will require employers with 100 or more employees to have vaccinated, full vaccination employees or weekly negative COVID testing. Here in Colorado, the city of Denver issued a public health order last month or the end of August, requiring employers who work with the city to have their employees, all of their employees, vaccinated before appearing on site at any city location. Now, these aren't binding legal authority like a Supreme Court decision, but they do offer significant legal bases for employers to require their employees to get vaccinated. Incentives for vaccinations is another issue that's popped up. Can you provide, say, a half day off for your employees if they provide proof of vaccination? Generally allowed. You are permitted to request documentation or confirmation regarding an employee's vaccination status. The EEOC has said that is not a disability-related inquiry under the ADA. So you're allowed to offer incentives to employees to voluntarily provide that documentation or confirmation, as long as the incentive is not so great that it would be considered coercive. Again, any documentation or confirmation concerning an employee's vaccination status must be kept confidential under the ADA. And note that while you may offer an incentive for employees to provide documentation or confirmation that they or their family members received the vaccination, GINA prohibits an employer offering incentive in return for an employee's family member getting vaccinated by the employer or its agent. To avoid pitfalls here with GINA and potentially other laws, we're advising employers the safest route is to have a third-party administer vaccinations if you're going to require employees to get vaccinated. You take on a lot more potential liability if you, for example, have somebody come on site at your location and provide vaccinations to your employees. Again, information about employees' COVID vaccination is confidential, has to be maintained as confidential, kept separate from the employee's personnel files. And like I mentioned, the applicable EEO laws do not prevent an employer from requiring employees to bring in documentation or provide some other confirmation of vaccination. So what do you do if you have an employee with a disability that prevents them from getting vaccinated? If you mandate vaccines for your employees, that will essentially be considered a safety-related standard, which if you apply it to all employees, if it's job-related and consistent with business necessity, you can require that disabled employees participate as well. If the disability prevents the employee from getting a vaccine, participating essentially in a safety-related standard, you can't require compliance unless the employee poses a direct threat to the health or safety of the employee or others. And these are the factors that the EEOC has said you should consider when determining whether or not the employee poses a direct threat to himself or other coworkers. But in the COVID context, what you should be looking at is look at the current medical knowledge about COVID, CDC and local health agencies are a great source for this information. Consider the level of community spread. Consider the type of work environment, whether the employee works inside or outside. Does the employee work alone? Is the workspace ventilated? How often is the employee interacting with others? How many coworkers are vaccinated? Are employees wearing masks? Is the workplace socially distanced? If you determine that an unvaccinated employee poses a direct threat, you'll want to look at whether there's a reasonable accommodation that will allow employee to perform the essential functions. And essentially, this is the interactive process again, same process as you would go through for a regular disability under the ADA. One thing we're telling employers is that if you do implement a vaccine requirement and provide a communication to employees about the vaccine requirement, we would recommend including information on that communication that the employer will consider a request for accommodation from the requirement based on disability or religion on an individualized basis. So I briefly mentioned the U.S. Department of Health and Human Services has classified long COVID as a potentially qualifying disability under the ADA. There's guidance at that link on the screen. Essentially a physiological condition that affects one or more body symptoms. Could include lung damage, heart damage, kidney damage, neurological damage. If it substantially limits a major life activity, it's going to be considered a disability under the ADA. And you'll have to go through the interactive process and determine whether there's a reasonable accommodation available. This is a pretty new condition, so the symptoms and steps necessary to reasonably accommodate an affected individual may vary. But I wanted to put this out there and put you all on notice that the U.S. Department of Health and Human Services has said this could be a qualifying disability under the ADA. And while this webinar is not intended to focus on OSHA, I thought I should at least mention some OSHA considerations with regards to COVID, because it should be one of the factors employers consider in moving forward with the vaccine policy. What are going to be the OSHA implications? We have the President Biden announced the COVID-19 action plan in September. As I mentioned, it's a broad scope of a vaccine mandate, or includes a broad scope of vaccine mandate, federal employers, contractors, employers, 100 or more employees. We have the emergency temporary standard that's forthcoming. It was provided to the Office of Management and Budget last week and should be published at some point soon. But still, the most relevant guidance for employers to look at, though, is the guidance from early September from the Biden administration as far as what the emergency temporary standard will include. We're expecting it to be modeled on the healthcare workers emergency temporary standard that was issued in June. Here's a copy of that emergency temporary standard. We expect the general emergency temporary standard to be similar in language and scope and requirements. Under OSHA, there's essentially two types of violations that an employer can commit. There's a general duty clause, which is your catch-all clause for OSHA, and then if there's a specific safety standard on point, employers can violate that as well and be issued a citation for violating the specific safety standard. The general duty clause, which a lot of people call the GDC, is found in Section 5A1 of the OSHA Act. Like I said, it's the catch-all. If an employer fails to keep a workplace free of a hazard to which employees are exposed, it's a recognized hazard likely to cause death or serious physical harm, and there's a feasible or economically viable way to correct it. This picture on the right demonstrates a probable GDC violation. While there may be OSHA specific safety standards for piping, there's no indication that piping here is unsafe on its own, but the piping appears to be used as a ladder by employees, which is probably a recognized hazard. And if an employee were to get hurt while climbing on the piping like this, it could lead to a GDC violation. Specific safety standard violations are found in Section 5A2 of the OSHA Act. Like I mentioned, when there's a specific OSHA safety rule on point that the employer fails to comply with, the employee has access to the condition, and the employer knew or should have known with the exercise of reasonable diligence of the existence of the unlawful condition, you could violate the specific safety standard portion of the OSHA Act. Here, this picture, there's a specific OSHA safety standard regarding ladders. It's 1926.1053. And I can assure you that this latter setup in no way conforms to the OSHA safety standard. So separate and apart from the GDC violation, OSHA could also issue a citation for violating specific safety standard. Presumably, once the forthcoming ETS is issued regarding the vaccine requirements, OSHA will be able to issue citations under Section 5A2 of the OSHA Act rather than just the GDC. This slide lists out the types of citations that OSHA can issue. There's 5 different classifications. We anticipate that violations of the vaccine ETS, whenever it is issued, will be considered either serious or willful. Now, you want to protect your employees and follow the law, but we also want to avoid getting sued by our employees. So I'm going to go through a quick litigation update. Between January 30th, 2020 and September 28th, which is when I ran this search, there were 3,599 COVID-related lawsuits filed nationwide. The most common case type was remote work and leave conflicts. And I can assure you that there are plenty of cases within that category that have to do with an employer failing to provide a reasonable accommodation for an employee's COVID-related disability. Litigation agency enforcement has forced employers into action, and an incorrect or poorly considered decision can lead to litigation. Most recently, there's a Kentucky hospital that was sued by its employees in September. Employees were alleging that they were coerced into being vaccinated and that the vaccine mandate violated their constitutional rights. The federal judge in that case upheld the employer's vaccine mandate on September 24th, stating that if the employee believes his or her individual liberties are more important than legally permissible conditions on his or her employment, that employee can and should choose to exercise another individual liberty, no less significant, the right to seek other employment. So far, all efforts to overturn employer vaccine mandates through litigation have failed. There's a similar lawsuit filed by hospital employees in Texas in June of 2021 that was also shot down. In total, we've seen more than 20 lawsuits across the country challenging vaccine mandates, and none of them have been successful. But litigation is costly, and employers need to defend themselves if they get sued. So takeaways from this case is that vaccine mandates are likely going to continue to be upheld, although it may create consternation amongst your employees, and your company may receive a visit from a process server with a lawsuit filed by employees. Like I mentioned earlier, if you have a vaccine mandate that you put into place, make sure you have robust religious accommodation and medical accommodation procedures in place. More recently, and more on point to this presentation, the EEOC sued an employer in Georgia for disability discrimination related to remote work. The EEOC filed the suit against the Georgia employer September 7th, 2021. Allegations include that the employee requested an accommodation to work from home 2 days a week prior to the pandemic. During the pandemic, the employer placed all of the employees on remote work. After the employer called the employees back to work, the employer renewed the accommodation request, which was denied. So the EEOC filed suit. This case really sheds light on what we've been talking about earlier. Employees' work from home arrangement during COVID will be used as a factor to consider in determining whether the employee can perform essential functions of the job while working remotely. It also provides a glimpse of how the EEOC is going to use this factor against employers who deny teleworking requests for accommodation. So the takeaways from this one is, while you're participating in good faith in the interactive process is key, but you want to pay particularly close attention to requests to telework. If an employer claims that remote work requests are not feasible, but the employer allowed remote work during the pandemic, that fact is going to be used against the employer. So if you're going to claim that continued remote work is going to create an undue burden on the company, make sure that you can articulate how. And if you provided equipment and access for employees to work remotely, that may undermine arguments you have that providing the equipment would impose an undue burden on the employer. At the end of the day, you want to make sure that these requests are being handled consistently. And there's no resolution of this case as of yet, but it will be important to future remote work requests by employees under the ADA. These are some ADA compliance best practices. These are important all the time, but especially during COVID. You'll want to document the reasonable accommodation process for each employee who requests an accommodation. Identify an individual at your company who focuses on the company's ADA compliance. Document, that's going to be the biggest recurring theme here. Document all reasonable accommodation options that were suggested, offered, requested, and how they worked. Don't terminate an employee who's received a reasonable accommodation until the interactive process has been documented and reviewed for potential liability exposure. And this goes back to loop in legal counsel if you are going to make an adverse employment decision regarding an employee fairly close in time to a reasonable accommodation request or denial, something like that. The last two are kind of no-brainers. Be reasonable and deal with your employees in good faith. Plan ahead and anticipate employee issues. So here's what we talked about. Talk about the ADA, its obligations that are imposed on employers. Talk about the definition of a disability during a pandemic, how that has kind of shifted a little bit, even though the EEOC says the laws are also applicable and that nothing has really changed. We talked about when you may be required to provide a reasonable accommodation. Note the difference between an accommodation for disability versus religion, the different thresholds that have to be met for each one of those different types of accommodations, the different types of accommodations that may be required. Be on the lookout for issues like harassment, retaliation, and associational discrimination. We talked about what types of inquiries you can make into employee status regarding COVID-19 symptoms, vaccination status, employer rights regarding vaccine requirements, long COVID as potential disability, and OSHA considerations. So with that, we'll open up to questions.
I believe Tracy, did you have a question for Jody? Do you just want to ask?
I was wondering about protected, or excuse me, it was vulnerable folks at home, and you had mentioned that. I'm sorry, Jody, you caught me off guard. You had mentioned that that we don't have to comply with someone's request to not come into work because they have someone at home who's high risk. My question was specific to kids under 12. Does that include kids under 12?
Yes. So essentially, it all boils down to your focus should be on the employee, on your employee as opposed to anybody around the employee. You're not required to provide any sort of reasonable accommodation to an employee based on the disability-related needs of somebody else or the vaccination status of somebody else. So all you need to look at is whether the employee, him or herself, does in fact have a disability that requires a reasonable accommodation. You don't need to look at anybody else.
Okay.
But one thing that I mentioned is that doesn't prohibit you from being flexible in these types of situations if it works for the company, and you're not. If your flexibility doesn't have a disparate impact on a protected group of employees. For example, if you're providing these types of accommodations for all of your 30-something white male employees, but you're not allowing 40-plus-year-old female employees to have the same sorts of accommodations, you may have another issue on your hand with gender or age discrimination. So just make sure that your flexibility is consistent. But yeah, exactly, you don't have to provide any sort of reasonable accommodation based on the needs of somebody other than your employee.
So now I have another question, and it's about ventilation in the workplace, and if that has any bearing on any of the OSHA parameters.
Right. So, as long as you're complying with OSHA standards regarding ventilation in the workplace, you should be fine as far as the general duty clause, a potential general duty clause violation. If you're providing a safe and healthy and clean workplace for your employees, you should be fine with regards to ventilation. You'll want to take a look at CDC guidelines regarding ventilation, any local or state health agency guidelines regarding ventilation, and if it makes sense to implement those, you're going to reduce your risk even more. But generally speaking, as long as you're complying with ventilation requirements that would be possibly set forth in OSHA, you'll be fine. I don't see a whole lot of issues there or increased risk.
Okay, great. Thank you.
Mm-hmm.
Thanks, Kim.
Yeah, of course. Does anybody else have any questions that they'd like to ask Jody? You're welcome just to raise your hand or just unmute yourself.
I have one question. This is Ann Lance from Teaching Tree. My question is about the leaves, the federal leaves that happened that I thought ended September 30th. Have those been extended?
No, so I think you're talking about the FFCRA, Federal Families First Coronavirus Response Act, which required employers to provide paid sick leave for most of 2020, and then that was extended to September 30th of this year on a voluntary basis for employers. That federal law has expired, and I don't believe that there's any sort of motivation in Congress to extend that any further. With that said, though, Colorado passed a law called the Healthy Families and Workplaces Act that went into effect at the beginning of, that went into effect last year, but for our purposes, it has supplemental paid sick leave requirements that essentially mirror the federal requirements under the FFCRA. And Colorado's Healthy Families and Workplaces Act requires employers to provide up to 80 hours of supplemental paid sick leave if there is a disaster emergency declared by the governor, or if there's a public health emergency declared by any applicable local, state, or federal official. In this case, the Secretary Becerra, I think I'm pronouncing his name correctly, who's the Secretary of Health and Human Services, the Federal Health and Human Services Department. He declared a public health emergency that he's been extending in 90-day intervals, and he most recently extended that on October 15th. So that will extend out into January, as a national level public health emergency, which will trigger employers in Colorado to provide supplemental paid sick leave under Colorado's State Healthy Families and Workplaces Act. It actually requires employers to provide that for 4 weeks after the expiration of the public health emergency. So there's a lot of different laws at play here, but essentially the Colorado state law still requires employers to provide up to 80 hours of supplemental paid sick leave to deal with the effects of COVID, just as the federal law required up until September 30th. The main difference between the laws is that the federal law allowed employers to recoup any amounts they paid out in paid sick leave based on, they're allowed to recoup it in tax credits. The state law doesn't have any sort of mechanism for employers to recoup those amounts paid out in paid sick leave. So you still have to provide up to 80 hours of paid sick leave for an employee to deal with COVID symptoms, but you're not going to be able to recover that amount under Colorado state law.
Is there an element of having the employee use their accrued sick leave first?
Yeah, under both of those laws, the federal law and the state law, employers can require employees to use accrued paid sick leave and paid time off, paid vacation, whatever, before they provide any paid sick leave under the law. And how that works is you'll just have them run concurrently. So you'll have to provide up to 80 hours of paid sick leave, but if an employee has 40 hours of paid vacation time, you can require them to use that for their first 40 hours of that 80 hours of paid supplemental paid sick leave.
So they wouldn't get 120 hours, they would get a total of 80? Okay, great, thank you.
Is that 80 hours in 1 year? So will like that start over in January?
It's 80 hours per public health emergency. So if you had an employee who used, 80 hours back in January or May of 2020 when the pandemic started, they wouldn't be entitled to any more paid sick leave under Colorado's law or the federal law before it expired. With that said, the Healthy Families and Workplaces Act also has a general paid sick leave component that in 2021 applies to employers with 16 or more employees, but January 1st, 2022, it'll apply to all Colorado employers, where you'll have to provide 1 hour of paid sick leave for every 30 hours worked for all your employees, up to 48 hours total. So when the public health emergency related to COVID expires, because presumably at some point it's going to expire, you'll still be required to provide that paid sick leave under the general provisions of Colorado's Healthy Families and Workplaces Act, 1 hour for 30 hours work, up to 48 hours total, based on the size of your home.
Sorry, one more question about that public health leave. Is that only if the employee is sick, or with the FFCRA, there was that about, if your kids were sick, you got 2/3 pay. Does that not happen with this FEL leave?
The supplemental paid sick leave under Colorado state law?
Yeah, does FEL include, you get paid if your child is sick or their school shuts down, you would get 2/3 pay. Is that gone?
Under the federal law, that is gone. Under Colorado's Healthy Families and Workplaces Act, you're still required to provide supplemental paid sick leave for essentially the same reasons that they would be entitled to it under the federal law. So employees could be entitled to take that supplemental paid sick leave to care for their own conditions, or to care for somebody in their family that has COVID that they're responsible for caring for, or if an employee has a kid whose school gets shut down or something like that. They'll be entitled to take that supplemental paid sick leave under Colorado law.
Okay, thanks.
Any other questions, guys? Well, you have Jody's email. I'm assuming, Jody, they can shoot you an email if they have further questions about any of the information you provided. But again, thank you so much for being with us, Jody, and for BKD for sponsoring our webinar. And please have a great day. Enjoy, well, I was going to say enjoy the weather, but it's getting kind of cold. So enjoy the cold weather out there, and we will see you next time. Thank you, guys.